Good morning. Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Bettencourt, Birdwell, Lamatia, Menendez, Middleton, Parker, Perry, Schwartner, Zaffarini, Paxton, Hughes.
Good morning. As is usual at this time during session, there are many committees meeting at the same time, and so senators will be in and out. Their members of their staffs are here participating and monitoring, and also monitoring via video. So we'll begin on the agenda, and the chair lays out Senate Bill 2087, Senate Bill 2087. Currently, there are 9 voluntary exemptions a person can claim from jury service. Let me be clear, these exemptions do not make one ineligible for jury service. Persons in these categories can serve if they wish to, but they have the option of claiming the exemption. A few of these are being over the age of 70, being a student of a secondary school or institution of higher education, or being an officer or an employee of the Senate, House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of government. That's current law. Senate Bill 2087 would expand the exemption for officers and employees of the legislative branch of government and would allow the spouse of the officer or employee to claim the exemption as well. That's all the bill does, and I'll yield for questions. Very good. We'll open public testimony. No one has registered to testify on, for, or against Senate Bill 2087, so we'll ask anyone present wishing to testify on, for, or against Senate Bill 2087. Seeing and hearing none, public testimony is closed, and the bill is left pending at this time.
The chair lays out Senate Bill 1649 and recognizes Senator Parker to explain the bill.
Thank you, Madam Chair. This bill aims to address issues raised by lawyers who practice trust law, who identified areas of the law that need to be modified to preclude unnecessary litigation due to a lack of clarity. There's been confusion in the legal community about the language needed for revocable trust to qualify as a homestead, as the property code and tax code have different provisions. Senate Bill 1649 updates the property code to reflect the same language as the tax code to allow a revocable trust to qualify for a homestead exemption. The bill also clarifies the provision related to the rule against perpetuities, which previously caused confusion, as it could allow people to believe that they get an additional 300 years for each trust created by the original trust, lending to essentially no rule against perpetuities. When a trust is declared into a new trust, there is confusion about whether the new trust can keep the name and employer identification number, the EIN, of the original trust. Senate Bill 1649 allows the new trust to use the same name and EIN as the old trust. In a trust proceeding, a court appointing a guardian ad litem must make a finding that a person's interests are inadequately represented before making the appointment, but the same finding is not required for an attorney ad litem. Senate Bill 1649 requires the court to find that the person's interests are inadequately represented before appointing an attorney ad litem. The passage of Senate Bill 1649 will help reduce confusion and litigation in trust law and ensure that the legal process runs more smoothly going forward. Thank you for considering, Madam Chair and members of the committee, this important piece of legislation, and I know we've got an excellent resource witness for us today as well.
Great. Well, thank you, Senator Parker. Members, are there any questions? I should say, member, is there any question? All right. If not, then we do have an invited witness. The chair calls Lauren Hunt.
Good morning, Vice Chair.
And if you could hold for just a second. Sorry about this. I do believe we have a committee sub. Senator Parker, is there a committee sub?
There is a committee sub, yes, so go ahead and lay that out.
The chair sends up the committee sub for 1649 by Parker and recognizes the author, Senator Parker, to explain the bill.
Well, thank you again, Madam Chair, and I'm going to have our resource witness take the members of the committee through the details of the differences between the original filed version and the substitute.
Thank you, Senator Parker. All right, we'll go back now to Lauren Hunt. Please state your name for the record and give us your testimony, please.
Good morning, Vice Chair Paxton and members of the committee. Thank you for having me this morning. My name is Lauren Hunt. I'm a trust and estate litigation attorney in Austin. I'm here on behalf of the Texas Real Estate and Probate Institute, known as TREP, which took over the legislative efforts of the Real Estate, Probate, and Trust Law section of the State Bar of Texas that does not carry legislation anymore. I'm speaking for the bill. TREP appreciates Senator Parker for carrying this bill for us today. Section 1 of the bill relates to what language is required for a revocable trust to qualify for homestead creditor protection. There are provisions about trust qualifying as homesteads in both the property code and the tax code, and the language as to what is required is different in each section. And so what we are wanting to do is modify the property code so that it has the same language as the tax code. There was a bankruptcy case a few years ago that said that a trust did not qualify for creditor protection because it used the tax code language. It's intended that both the language be the same. So we're just modifying it to add the same tax language into the property code. The next provision in this bill makes clear that in Texas, if a person holds a testamentary general power of appointment over trust property, the assets that are subject to that power are not subject to a creditor's claims unless the person who's holding the power actually exercises the power of appointment and tries to transfer the property. So the trust property remains safe from creditor claims unless they try and move the property. The next provision deals with the new rule against perpetuities that passed last session and clarifies an ambiguity in that law that relates to the effective date. So a lot of trust instruments have an original trust, and then the trust will terminate and a new trust will be created, and that can happen repeatedly. And the way that the current statute is written about the effective date of the trust could be read to be interpreted that each successive new trust gets a new 300-year counting period. So this provision would make clear that any of the trusts under the one instrument would start with the effective date of the first trust, and you get the 300 years from that date for all the trusts. Additionally, in the rule against perpetuities portion, we have a very hyper-technical kind of law professor provision that just says that the trust must vest no later than the later of 300 years after the effective date or 21 years after a life in being plus a period of gestation. This reflects kind of the fertile octogenarian issue that I think a lot of us learned about in law school. We called this the Methuselah issue. It's more of a theoretical issue, hyper-technical, but it sets the outward limit of the period. Section 4 of the bill clarifies that when you're decanting one trust into a second trust, the second trust can take on the same name and the identification number as the first trust. And then the last section says that if a court appoints an attorney ad litem in a trust proceeding, the court has to find that the person's interests are inadequately represented before they appoint an attorney ad litem. The committee sub reflects just a couple of changes. One of the provisions of this, it refers to spouses as settlors of a trust. It's not always spouses. Usually when you have two settlors, they're spouses, but we just changed the word to person to reflect all situations. And then we additionally removed, initially we were going to take section 112.036F of the RAP provisions and move it to its own section. We decided to not do that, so we've removed that. And then there's a provision that referred to the new provision that we were going to move out to its own provision, and we've just removed that. So thank you for having me today. I'm open for any questions you may have.
Thank you. And I learned a new term, fertile octogenarian.
Yes.
So very self-explanatory. So members, are there any questions for our witness? All right, if not, thank you, and appreciate you being here.
Thank you. Appreciate it. Thank you.
We will now open public testimony. We don't have anyone registered, but let me go on and ask in the chamber, do we have anyone who wishes to testify on, for, or against Senate Bill 1649? If not, the bill will be left pending until the call, subject to the call of chair. Chair lays out Senate Bill 1373 and recognizes Senator Parker to lay out the bill for the author, Senator Hughes.
Thank you, Madam Chair. Honored to bring forward this bill for Chairman Hughes pertaining to Senate Bill 1373. Each session, the Texas Real Estate and Probate Institute brings us ways to help clean up state law. Senate Bill 1373 is that bill, specifically in relation to the disposition of decedents and multi-party estates. Last session, a similar version of this bill passed the House unanimously. I can attest to that personally, and was set to pass on the last Senate local and contested calendar, but died on the last day. There is a witness here to testify and answer any questions the committee might have. And of course, I know Senator Hughes is passionate about making certain we get this bill passed this session.
Thank you, Senator Parker. Member, is there any questions? All right. If not, then we will have our invited witness, Lauren Hunt, make a reappearance. If you'll take a seat. And again, state your name for the record and give us your testimony, please.
All right. Thank you, Vice Chairwoman, Ms. Paxton, and members of the committee. Again, my name is Lauren Hunt. I'm with the Texas Real Estate and Probate Institute. I am here for another kind of technical legalese kind of bill, and I appreciate Chairman Hughes carrying this bill for us. The first provision in this bill relates to how notice is given to certain estates in certain estates proceedings. Practitioners, in most cases, are required to give notice by certified mail, return receipt requested. And what we're finding is a lot of times we're not getting the green cards back, which we need to show as proof that we have actually served someone. So this would open up other options to practitioners to use what's called qualified delivery method, which includes private delivery service, which is something that is defined in the Internal Revenue Code, and it essentially opens it up to FedEx, USPS, those kinds of things, so that we have other options available. The next provision clarifies which community property assets of a married couple are subject to certain creditors' claims when a spouse dies. This is not a change in law, it just has to do with when the probate code became the estates code, there was a word inadvertently left out or modified. And it made it look like only the deceased spouse's assets were subject to the claims of the creditors of the community. So we're clarifying it's both spouses. The next provision specifies that during the administration of the deceased spouse's estate, the surviving spouse can retain possession, control, and power over property that was the surviving spouse's sole management community property during the spouse's life, this deceased spouse's life. The next provision clarifies with respect to multi-party accounts that the term account does include securities, cash deposits, or an account holding stocks, bonds, and mutual funds. I think most practitioners believed that already, but this clarifies that. The next provision clarifies that an heirship application only has to list property that would be governed by a judgment in the proceeding. So if you have property outside of Texas, you don't have to list that property in the heirship application because the court doesn't have jurisdiction over that property. The bill also allows a court to consider as evidence of for an heirship a sworn affidavit of heirship that's been on record in the property records for at least 5 years. And the bill allows a person who's a creditor of the estate to serve as a witness in an heirship proceeding if that person's otherwise disinterested and credible. This usually comes up if someone has loaned money for a funeral or something like that. They're a family friend, and they're the only one who can really testify as to the heirs. We want them to be able to testify in that situation. The next provision allows parents or guardians to waive citation of certain heirship or probate proceedings on behalf of minors. Currently, if you have a minor who is over the age of 12, nobody can waive service and they have to be served with process, which can be terrifying for some children. And so we want, if they're under 16, we want their parents or guardians to be able to waive service for them, and if they're over 16, for them, the child to be able to waive their own service. The next portion of the bill clarifies that certain provisions of the code do not apply to a written will that's executed in compliance with foreign country or a foreign state. We also would, a provision allows a person who's been convicted of a felony to qualify as an executor or administrator of an estate if all of the distributees of the estate recognize in writing that they are aware of the felony and they still want the person to serve. And even then, the judge still would have discretion as to whether to appoint them. Our next provision allows an unsworn declaration in lieu of sworn oath to be used for those who are qualifying as personal representatives of an estate. And finally, the bill applies existing provisions that address the sale of real property or real estate and a dependent administration to the sale of personal property and a dependent administration. I thank you for your time, and I'm here to answer any questions you may have.
Thank you so much. Members, any questions for our witness?
No questions for me, Madam Chair.
Thank you so much for being here today and helping us understand those things. The chair will now open public testimony. We don't have anyone registered to testify, but let me go on and call to the chamber. Is there anyone here who wishes to testify on, for, or against Senate Bill 1373? If not, the bill will be left pending. All right. The chair now lays out Senate Bill 1092 and recognizes Senator Parker, the author, to explain the bill.
Thank you, Madam Chair. Appreciate the opportunity to come before you and the members this morning. Senate Bill 1092 grants the Supreme Court of Texas final review authority and original jurisdiction to issue corrective writs in cases where the Texas Court of Criminal Appeals voids a statute, rule, or procedure on constitutional grounds. Our state features a bifurcated appellate review system under which the Supreme Court of Texas has final appellate jurisdiction over civil cases, and the Texas Court of Criminal Appeals has final appellate jurisdiction over criminal cases. This bifurcated system allows for Texas's high courts to specialize in their respective areas of law, an advantage that can only be maintained by clear legislative guidance on the scope of each court's jurisdiction. When the Court of Criminal Appeals strikes down statutes on constitutional grounds, it acts beyond its jurisdictional area of specialty by deciding constitutional questions properly reserved for the Supreme Court. Senate Bill 1092 remedies that problem by providing much-needed jurisdictional guidance for cases in which the Court of Criminal Appeals determines that a statute, rule, or procedure violates the state or federal constitution. This bill provides that in such cases, the ruling of the Court of Criminal Appeals does not become final for 60 days or until the Supreme Court declines to review the ruling. The bill further grants the Supreme Court original jurisdiction to correct the Court of Criminal Appeals' determination of unconstitutionality by issuing writs of mandamus or quo warranto upon the request of a qualifying judicial officer. Article 5 of the Texas Constitution empowers this legislature to issue such guidance via ordinary legislative enactment. Thank you, Madam Chair and members, for allowing me to lay out before us Senate Bill 1092. I do have a wonderful expert witness here to testify as well this morning.
Thank you, Senator Parker. Members, are there any questions for Senator Parker on the bill? If not, I'll take just a moment to acknowledge and reflect that Senator Perry has arrived. Welcome. And did you wish to call the witness, the resource witness?
Please, I would like to.
Witness? All
Yes,
right.
Madam Chair.
All right, the chair then calls Grant Dorfman. Welcome to the
morning.
chamber, and if you would state your name and give us your testimony, please.
Thank you, Madam Chair. Grant Dorfman, Texas Office Attorney General, here as a resource on the bill. If I may make just, I think Senator Parker summarized it very well, but I was 10 years as a state district trial judge in the Harris County Civil District Courts, and we had constitutional notification requirements in that. I always viewed that as a way to maintain the consistency in Texas jurisprudence to allow the Office of Attorney General to make the best arguments on notice that a constitutional provision that this legislature or law that this legislature had passed was given its best day in court and its best defense in important cases. And to me, this is a logical extension of that in a situation that's fairly unique among the states of this country, where only Texas and Oklahoma have a split Supreme Court that divides criminal and civil jurisdiction. And in those situations, as we had in Harris County for that matter, between the First and 14th Court of Appeals, there's two authorities. These courts aren't infallible. They're not final because they're infallible because they're final, except when you have two concurrent coordinate courts, there's the potential for conflicts in their interpretation of Texas laws and Texas jurisprudence. And this bill, I think, is a salutary effort to address that conflict so that there is consistency in the jurisprudence of the state in important constitutional questions, and the legislature's authority is protected in that respect.
Thank you, Mr. Dorfman. Members, are there any questions?
Madam Chair.
Yes, Senator Parker, you're recognized.
Thank you, sir, for being here. Really appreciate you being a resource witness for us this morning. Just a very technical question again. Why, in your assessment, do we not need a constitutional amendment to achieve the outcome that the legislation that I'm carrying addresses? If you might speak to that for a moment, that'd be very beneficial.
Yes, Senator. The Article 5 of the Constitution sets out the duties of the Judicial Department and specifies the jurisdiction of the Supreme Court and the Court of Criminal Appeals, and says that the appellate jurisdiction of each in their separate spheres, civil and criminal, shall be final, except as otherwise provided by law. And in that case, if the legislature were to pass a law, as I read it, the law itself is already authorized by the Constitution for the legislature to confer that provision and the powers of an appellate nature, of course, on the Supreme Court.
Excellent. And one other item, and you really referenced it already in your testimony, but I want us to kind of drive it further home. The concept, the fact that this split system really only exists here and in Oklahoma. The rest of the country doesn't do that. Maybe just elaborate on that further for a moment, if you wouldn't mind, Judge.
Yes. There's a long history of why it's so in Texas. I'll spare the body that discussion. But again, only Texas and Oklahoma have a separate criminal Supreme Court and separate civil Supreme Court. And obviously, the nature of those cases are very different, so that the criminal system is inherently case-oriented. You rarely don't have class action suits or suits that are inherently constitutional challenges in nature, as you frequently do at the Texas Supreme Court, or cases end up there with those aspects to them. Here you're talking in the criminal sphere of a case that comes up from the trial court involving a crime, an alleged crime, a criminal defendant at that point adjudicated presumably guilty and therefore on appeal. And in that situation, you have the criminal defense lawyer and the state, usually represented by the district attorney, making arguments. And the constitutionality of a state law may come up in the context of that prosecution, but it's narrowed to that set of circumstances. and that individual case, and whether that individual should go to jail for a set period of time or face other criminal consequences with the burdens of proof that pertain in that situation. So the constitutional challenges that the Court of Criminal Appeals deals with come in a very specific set of circumstances and unique individualized cases. The Texas Supreme Court is charged with the maintenance of the jurisprudence of the state of Texas. That's one of the grounds they consider when they grant or deny a petition for review. Is it important to the jurisprudence of the state that this question be addressed and resolved by us? The Court of Criminal Appeals is more inherently focused, again, on that criminal defendant and what the punishment should be, if any, in that situation. So I think the unique nature of that warrants some, well, I previously said I think there needs to be a final decision maker, otherwise you inherently have conflicts, even with the best of intentions and the best of legal minds on both sides.
Absolutely. I couldn't agree more. And I don't know if you want to comment on this, but from my perspective, just for the members' benefit, public testimony benefit, Republicans and Democrats have been concerned with this issue over many years. So it's really, truly been a bipartisan concern from a historical perspective. So appreciate you answering those questions and being here to provide some expert testimony. Thank you for your service as a judge. Thank you for your service to Texas as a member of the team at the Attorney General's office. So we appreciate you, Senator. Thank you, sir.
Thank you. Members, are there any other questions? If not, thank you, Mr. Dorfman, for being here. If you see anybody I know, tell them hi. And you're excused. And if there are no other questions for our witness, we will open public testimony. We don't have anyone registered, but let me ask in the chamber if there's anyone here who wishes to testify on, for, or against Senate Bill 1092. If not, the bill will be left pending. And we have guest Senator Huffman coming to lay out 3 bills this morning. Welcome, Senator Huffman.
Welcome. Thank you. All right, sorry.
The chair lays out Senate Bill 23 and recognizes the author, Senator Huffman, to explain the bill.
All right. Thank you, Madam Chairwoman and members. Since 2019, Texas has seen a massive spike in violent crime with the use of a firearm. In Houston alone, as reported by the Houston Police Department, there were 427 murders in 2020, 477 murders in 21, 435 murders in 2022. These numbers drastically increased from the 291 murders in 2019 prior to the COVID-19 pandemic. Mandatory sentences act as a potential deterrent for anyone considering illegally using a firearm and are a tool for prosecutors to keep violent criminals off the streets. Senate Bill 23 establishes a 10-year mandatory minimum sentence for the use of a firearm in the commission of the most severe felony offenses under Article 42A.054 of the Code of Criminal Procedure. In Texas, these are sometimes referred to as 3G offenses that have been distinguished by the legislature as the worst of the worst. To be eligible for the 10-year mandatory sentence, the bill requires an affirmative finding that the deadly weapon used in the commission of the crime was a firearm. And members, I want to remind you that many times these offenses are committed with the use of a deadly weapon that are not necessarily a firearm. They can be a knife. Sometimes hands can be a deadly weapon. This bill is only focused on gun violence, so it's really just if a firearm, as defined by the penal code, is used in the commission of the offense. The bill requires 10 calendar years served for these offenses and removes the possibility for jury-recommended community supervision, judge-granted deferred adjudication, community supervision on parole. I will say the committee substitute, upon further consideration, will adjust the restrictions on jury-recommended community supervision and judge-granted deferred adjudication community supervision. I do have a committee substitute. If I could ask a member to send that up for me.
Thank you. Senator Huffman has a committee substitute for Senate Bill 23. The chair lays out the committee sub for Senate Bill 23 and recognizes Senator Huffman to explain it.
Thank you. Members, reflecting on my time as a judge, there were a small number of cases where, while the defendant was determined to be guilty and there was the use of a firearm in the commission of some of these offenses, the jury recognized that certain aspects of the case were extremely unique and allowed for community supervision. As I said, I reflected on this, and I actually recalled a specific case. Senator Perry, I prayed on it, as you often recommend, and thought about it, and realized that there were instances where if 12 citizens determined that it was the appropriate thing, that should still be allowed within the law. I will say there's been some discussion about this bill and the concern about self-defense. This bill does not change the law on self-defense at all. It doesn't go into those chapters. It doesn't affect them at all. The law of self-defense is still a very robust part of the criminal justice system and the rights that have been afforded citizens by this legislature and by, of course, the Constitution of the United States and Texas Constitution. And this bill does not affect this. It has been the law for some time, and I don't know exactly when it was put into the law, but the law is currently now that you can't get probation for murder. That's been the law. So I'm not changing that. That's been the law. The jury couldn't do that anyway. But under my bill, they could for some of the other offenses involving a firearm. If an individual does receive community supervision for an offense under this legislation, the committee substitute requires it to last for a minimum of 10 years. So the minimum sentence, if you directly go to prison, is 10, and if you get community supervision, that have to last 10 years. Furthermore, an offender who commits an additional offense while on a jury-recommended community supervision will have their punishment stacked. So if they're given that opportunity, but they blow it, commit a new offense, then that new offense can be stacked upon their 10-year sentence. Finally, the committee substitute clarifies that and there was some confusion on this, clarifies that the restriction on a judge's ability to grant deferred adjudication, community supervision, remember that's different than regular community supervision. It gets complicated, but that's when the judge, they make no finding of guilt. There's not really a conviction, but they serve a deferred sentence for X number of years. And if they can successfully complete it, then they end without a felony conviction. So it still allows, the committee substitute still allows judges to grant community supervision to certain offenses, but also where they can't, it only applies to felony offenses, again, the most violent ones under Article 42A.054, if there is an affirmative finding, again, that a firearm was used in the commission of the offense. The original file version applied to all felony offenses when a firearm was used, even third degrees and so forth. That was not the intent of my legislation. You kind of had to dig into it, really study it to figure it out. Members, I do believe this bill will allow Texas to take a stand against the illegal use of firearms in the commission of a crime, and I'd like to thank the Lieutenant Governor for making this public safety the crisis we're facing in our state, and it is across not just a Houston problem. I know some of the members give us Houston people a hard time, but it is really offenses and problems happening throughout the state, and this, I think, will go a long way as a deterrent effect to try to stop some of the very violent crimes that are happening in our state with the use of firearms. And I'm happy to answer questions. I know it's a little confusing, but it digs into a couple of different parts of the Code of Criminal Procedure and the Penal Code.
Thank you, Senator Huffman. Members, are there any questions? Yes, Senator LaMantia, you are recognized.
Thank you, Madam Chair. Thank you, Senator Huffman, for bringing this bill. I had a question. I know this bill applies across the board, right? So does that also apply to juvenile cases?
It would only apply in a juvenile case where a juvenile had been certified and was in an adult court. And that happens sometimes, I think 16 and above. If the juvenile system has certified them to stand trial as an adult, then it would apply. The juvenile system is different on mandatories and how they, affect sentencing and so forth. So this would only apply to a juvenile who ended up in the adult system which does happen, but again, it's unique and rare. I'm not going to say it's rare because I don't know how often it's happening all over the state now, but it does happen. But
So it would not apply to juvenile court?
it would not apply until the juvenile had been sent to adult court.
Great, thank you. Thank you.
Thank you. Any other questions? All right.
All right, thank you.
Thank you, Senator Huffman. And we will now open public testimony. We do have one resource witness, Shannon Edmonds, who is here. Members, do you have any questions for the resource witness? All right. Then we will move on to public testimony. The chair calls David Gonzalez, Wesley Verdell, Emily Taylor, and Betty Blackwell. David Gonzalez, Wesley Verdell, Emily Taylor, and Betty Blackwell. Well, thank you all for being here today. And if it's all right, I'll just ask you to start on this side, so you may need to get a little bit closer. And you have 2 minutes for your testimony, and
Thank you.
So we appreciate you respecting the time so we can give everyone a chance to speak. State your name and give us your testimony, please.
Thank you. I'm Betty Blackwell. I'm opposed to...
Can you move up a little closer?
A little closer?
There you go.
I am Betty Blackwell, and here with Texas Criminal Defense Lawyers Association. Practiced in this area for 40 years, testifying in front of this astute body. We are here opposed to this bill, mainly because one of our biggest concerns is our accomplice law is very, very broad. That means somebody can be charged for helping somebody, encouraging somebody before, during, or after a crime, and be charged with the same crime and convicted of the same crime in which this would apply. That means the kids in the car, the 16, 17, 16-year-olds that are certified as an adult in the car can be charged with the robbery of somebody going into the store with a gun. And we think it just throws such a big net that it would catch a lot of people that it really didn't intend to because of our very, very broad statute. David has some other concerns, but that was my point that I wanted to make before the committee if they had any questions.
Thank you so much. And members, if it's all right, we'll wait till everyone gives their testimony, and then we'll ask questions of the full panel. Thank you for being here. If you'd state your name for the record and give us your testimony, please.
Absolutely. My name is Emily Taylor. I'm testifying against this bill. I'm a criminal defense attorney out of Houston. I'm a partner with the law firm of Walker and Taylor. Our firm handles firearm and self-defense issues, and I am a criminal defense practitioner. I represent persons who have been accused of self-defense offenses, they have alleged a self-defense as a defense. I also represent law enforcement officers who have defensive, deadly force and force issues while on duty. Our concern is, and to Senator Huffman's point, though this doesn't open up Chapter 9 of the Texas Penal Code, our concern is that anti-gun prosecutors and anti-police prosecutors will use this law as a sword to essentially force persons to trial, many of whom will not be able to afford the trial fee. And it will catch people who act objectively, unreasonably in self-defense, yet subjectively and honestly in fear, in this net of a 10-year sentence with limited opportunity for deferred adjudication. Unfortunately, and my apologies to Mr. Edmonds, there are many, many prosecutors who will not reduce or dismiss a case simply because there's a firearm involved. And it really does scoop up people who are honestly protecting themselves and their families into this broad net that we've spoken about already.
Thank you. If you'd please state your name. And,
Thank you. My name is
testimony.
Wesley Verdell. I represent Gun Owners of America. I'm the Texas State Director for GOA. We are opposed to SB 23. Is that too loud by chance? No, all right. Anyways, while we want to see fair and just punishment for anyone who has committed a crime, this bill has unintended consequences for citizens who believe they do act in self-defense. If they're convicted, they will then be facing 10 years with no early release, This bill would also have the same consequences for law enforcement officers who believe they have acted in self-defense. We know that extended sentences do not reduce crime. Most offenders commit the crime while under the influence of drugs or alcohol, or they are emotionally unstable, and they don't take into consideration the actual penalty of the crime. We do not believe that this bill would achieve the goal to reduce crime, and it will make lives harder for those who acted in self-defense and their families. While we truly believe in fair and just punishment, a one-size-fits-all approach is not the solution.
Thank you for your testimony. Welcome. Please state your name and give us your testimony, please.
My name is David Gonzalez with the Texas Criminal Defense Lawyers Association, testifying in opposition of SB 23. We appreciate your committee substitute, and we acknowledge that on 3G offenses, it's very narrow in terms of the offenses and the conduct that we're looking to be able to prevent recurrence using a very strict deterrent of a mandatory minimum. Categorically, we oppose mandatory minimums, and we seek your assistance in a couple of areas. First, BB guns and airsoft guns. There's a case from the Court of Criminal Appeals that says that airsoft guns and paintball guns aren't deadly weapons per se, but they could be. And so if we see clarification that a firearm means not something spring-loaded or CO2 cartridge-loaded, I think that's more consistent, because while certified 16-year-olds are adults, in Texas, 17-year-olds are adults, and 18-year-olds, and 19-year-olds, and knuckleheads in that age up until 24 or so till your brain stops cooking. We practice a lot of juvenile law and see a lot of dumb things with BB guns, and I think they're different than the type of firearms that cause deadly weapons, that cause the kind of death and injury. Second is, to Betty's point, use is a very broad term, and the federal government in their sentencing guidelines makes distinctions between discharge, brandish, display, and use. And some of the cases just say if there's a gun in the car and you're evading arrest, did you use it? And if a 10-year mandatory minimum applies for that, we have those concerns. We think brandishing and discharging are very different. The word personal use makes a difference in both the law parties. But by saying simply in that word, if a person personally used a firearm, we think that would narrow substantially the reach of the bill. Thank you very much.
Thank you for your testimony. Members, are there any questions for the panel? If not, thank you. I appreciate you being here today.
Excellent.
I think that's all of our registered witnesses. Is there anyone else here today who wishes to testify on, for, or against Senate Bill 23? Seeing none, the bill will be left pending. Chair recognizes Senator Huffman to lay out Senate Bill 21.
Thank you, Mr. Chairman and members. Members, judicial discretion is an important tenet of the judiciary, preserving a judge's separation of powers and ensuring an equitable legal process. But it is imperative that discretion work within the confines of state laws passed by duly elected members of the legislature. Unfortunately, there have been complaints that certain judges have abused this discretion and completely disregarded state laws in order to push personal agendas. The State Commission on Judicial Conduct is a commission created to protect the public, promote public confidence in the integrity, independence, competence, and impartiality of the judiciary, and encourage judges to maintain high standards of conduct both on and off the bench. In recent years, there has been a lack of consistency surrounding reviewal timelines for complaints submitted to the Commission. Additionally, the Commission is limited in the types of complaints it is allowed to review and the punishments that can be handed down for judicial misconduct. Senate Bill 21 would expand the State Commission on Judicial Conduct and the legislature's ability to examine judicial decisions that have immediate effects on public safety and individual liberties, along with making changes to timelines surrounding complaints to the Commission. Specifically, the bill provides that as soon as practical after a complaint is filed, Commission staff must conduct a preliminary investigation and draft recommendations for the Commission to consider. Upon completion of the preliminary investigation and submission of recommendations, Commission staff must notify the judge of number one, the complaint, the results of the preliminary investigation, the recommendations, and the judge's right to attend each Commission meeting at which the complaint is included in the Commissioner's report. The bill states that no later than the 10th business day before a scheduled Commission meeting, Commission staff must prepare a report for each Commissioner detailing each complaint for which a preliminary investigation has been conducted, but the investigation report has not been finalized, and results of the preliminary investigation and related recommendations. Not later than the 120th day following the date of the first Commission meeting at which a complaint is included in the Commissioner's preliminary investigation reports, the Commission must finalize the investigation report and determine any action. This bill allows the Commission to order an investigation extension of not more than 240 days if it is not finalized by the 120th day deadline. If a judge is subject to formal proceedings initiated by the Commission, the judge shall be suspended from their position without pay until the final disposition of the proceedings. This will occur 10 days after the appointment of a special master, unless the special master determines that a suspension is not warranted. The bill also prohibits judges disciplined more than once from being eligible to serve as a visiting judge. Additionally, the bill allows the Commission and the Legislature to examine persistent or willful violations of bail proceedings under Article 1715, the Code of Criminal Procedure, which are a lot of the new bail laws that we passed have been working on last session and this session. The bill requires that if the Commission issues a public reprimand of a judge for violations of bail proceedings under Article 1715, the reprimand must include a 60-day suspension without pay. Again, members, this is an attempt to try to make the judges follow the law that has been implemented pretty much almost overwhelmingly by this legislature, almost unanimously, with some dissent, but not very much. Notification must be given to the legislature and comptroller of any suspensions under this article. So the legislature will know what's happening, and the comptroller is able to withhold the pay that would be going to the judge. Following, I have a committee substitute, if someone could send it up. I'm sorry, I'm in your seat. Is that okay? May I set up or someone set up a committee sub, please?
All right.
Yeah.
Thank you, Senator Huffman. Senator Parker sends up the committee sub for Senate Bill 21. The chair recognizes Senator Huffman to explain the difference between the committee sub and the original bill.
All right. After some discussions with the State Commission on Judicial Conduct, the committee substitute extends timeline requirements for the staff to prepare and disseminate notices of action to judges following commission meetings. The committee substitute also extends the time to give a judge notice of action to within 5 business days and to publish a notice of action on the Commission's website within 7 business days. Members, as a former judge, I do have a deep appreciation for judicial discretion and the role our judges play in the criminal justice system. That is why reports of the abuse of this discretion are incredibly disturbing. These judicial decisions have immediate effects on the safety of alleged victims in our communities. If certain judges, and it's not all judges, but if certain judges continue to disregard the laws of Texas and their oath of office, I am committed to taking further action to ensure that the Commission on Judicial Conduct has the structure and power in place to swiftly address any official misconduct.
Thank you, Senator Huffman. Members, are there any questions? All right. The clerk will note that Senator Middleton has arrived. And no invited testimony. Okay. All right. We do have a resource witness, Zendia Thomas.
Okay.
And the chair will open public testimony now. Chair calls Susana Carranza. Okay. And the resource witness, Zendia Thomas, you're welcome to come to the table if you would like to come, and if you don't have prepared remarks. Then you don't have to come. Well,
Yeah, no, I don't have prepared remarks. I'm Zindia Thomas, General Counsel of the State Commission on Judicial Conduct. I don't have any prepared remarks. I'm just here to answer any questions.
thank you. Members, any questions? Thank you. The chair calls, again, Susana Carranza. All right. I do not see Dr. Carranza. All right. If there is anyone else who wishes to speak on, for, or against Senate Bill 21, seeing none, public testimony is now closed. All right. Senator Huffman, are you ready for Senate Bill 20?
I certainly am. Thank you.
The chair lays out Senate Bill 20 and recognizes Senator Huffman to explain the bill.
Thank you, Mr. Chairman and members. Members, under Article 16 of the Texas Constitution, elected and appointed officers, including prosecuting attorneys, take an oath of affirmation to preserve, protect, and defend the Constitution and the laws of the United States and of this state. Same oath that we've taken, actually. Prosecutors have discretion in determining if probable cause exists that a suspect committed a criminal offense and that it can be proven beyond a reasonable doubt at trial. But the Constitution requires that these determinations be made for all state laws and not just ones that a prosecutor personally deems appropriate. Unfortunately, certain Texas prosecutors have joined a trend of adopting internal policies refusing to prosecute particular laws. These actions set a dangerous precedent and severely undermine the authority of the legislature. Senate Bill 20 bars prosecuting attorneys from materially limiting or prohibiting the enforcement of any criminal offense, whether that be by adopting an enforcing policy or by demonstrating by pattern or practice. Policy is defined as a formal written rule or policy and an informal unwritten policy. Additionally, the bill restricts a prosecuting attorney from materially limiting or prohibiting an attorney or peace officer within the same jurisdiction from enforcing a criminal offense. A prosecuting attorney who violates these provisions commits official misconduct and would be subject to removal under Chapter 87, Subchapter A of the Local Government Code. Basically, under Chapter 87, a proceeding for the removal of a prosecuting attorney can be initiated by any resident of the county for more than 6 months by filing a written petition for removal. The district court judge to whom the petition was submitted may issue a citation or dismiss the petition depending on merit, temporarily suspend the officer, or conduct a trial by jury for the removal. I think we have seen this happen in El Paso. Since filing this bill, I have a committee substitute. I would ask someone to stand up.
Thank you. Senator Huffman. Senator LaMantia sends up the committee sub, and the chair recognizes Senator Huffman to explain the difference between the original bill and the committee sub.
All right. Since I filed a bill, I heard from a lot of prosecutors. So I worked with prosecutors, and I have incorporated some of their recommendations into this committee substitute, which still certainly works. Bill still works, but working with the prosecutors as well. First, the committee substitute redefines policy as including an instruction or directive expressed in any way. Still, I think, takes care of the spirit of what we are trying to accomplish here. It also changes the standard for removal of a prosecuting attorney who in any way refuses to prosecute a class or type of criminal offense other than to comply with an injunction, judgment, or order issued by a court. This standard is aligned with a prosecuting attorney permitting an attorney under their control from prosecuting a class or type of criminal offense other than to comply with an injunction, judgment, or order issued by a court. Members, when a prosecutor refuses to enforce Texas law and disregard their oath of office, there must be a mechanism in place to remove them from office. Happy to answer any questions.
Thank you, Senator Huffman. Members, are there any questions of the author? Senator Parker, you're recognized.
Thank you, Madam Chair. Well, thank you, Madam Chair, for bringing forward this great piece of legislation, and I'm honored to join author it with you. I think it's very timely. I think from my perspective, I know you share the same vision. We're not trying to shut down prosecutorial discretion.
Of course not.
We want DAs to do so in the course of their normal practice on a case-by-case basis. but not to go and enact, broad sweeping commentary about classes of offenses. And effectively, in the end, they're not following the law in that regard, and it's a dereliction of duty. That's my perspective. I know it's your concern as well, and why you're bringing it forward.
Exactly.
So I just want to thank you for doing that. Again, I can't stress enough for everybody in the public at large and for all of our prosecutors that discretion is very important. But when it goes from being individual discretion on a case-by-case basis to prosecutorial legislation across large sweeping types of crime, then that's where we have a problem. We've gone too far, and that's why this legislation, I think, is so important. So thank you for bringing it forward, and excited to see its passage. Thank you.
Thank you.
Members, any other questions? If not, we will go in and open public testimony. The chair calls Jennifer Szymanski, Andrew Hendrickson, Rebecca Parma, Susanna Carranza, and Joe Poyman. If you would make your way to the table. And we have 2 minutes. Thanks for staying within the time. All right. I think we can call one more. Okay. All right. Well, thank you all for being here today. Appreciate you coming and offering your testimony. And we'll just go from left to right. And members, if it's all right, we'll let everyone testify, and then we'll ask questions at the end if there are any questions. So if you'd get us started, state your name and give us your testimony, please.
I'm Jennifer Szymanski, Director of Public Affairs for the Combined Law Enforcement Associations of Texas, or CLEAT. We represent over 27,000 law enforcement officers across the state, including the associations with the Austin PD, Fort Worth PD, San Antonio PD, El Paso PD, Dallas PD, Corpus PD, and all of the large urban counties. Several of the major cities across the state are facing a public safety crisis. Today, I'll focus my testimony on Austin and the George Soros-funded DA who has played a role in the destruction of the Austin Police Department. A DA who ran a campaign on prosecuting cops and letting criminals roam free is our reality, and he's living up to his promise as he has indicted 19 Austin police officers on first-degree felony charges. Those officers are facing life in prison for defending police headquarters on Interstate I-35 during the 2020 riots. The spike in crime and mass officer resignations are a direct result of willful neglect to prosecute certain offenses, such as theft, narcotics, firearms violations, etc. Peace officers are sworn to uphold the law and place themselves in harm's way every day to do just that, only for the district attorney to follow behind them and release suspects, sometimes even before the officer can get back in sector, because they don't believe certain offenses should be illegal, or they'd rather focus their efforts on prosecuting police officers. In Travis County, we have a district attorney who entered into a standing order or an agreement with the district judges. The document or the order was filed in district court to release suspects prior to magistration on certain charges they have determined they will not prosecute across the board. Every morning, police executives across this county receive a list of suspects released under these conditions. Just to review, these drop charges have nothing to do with probable cause and are dropped prior to magistration, just a very short time after booking takes place. I'm not sure how officers are expected to operate under these conditions. Thank you for this bill.
Thank you so much. If you'd please state your name and give us your testimony.
Thank you, Madam Chair and committee members. My name is Andrew Hendrickson. I represent the ACLU of Texas, and I'm testifying against SB 20. I want to open by thanking Senator Huffman and her staff for all their work on the committee substitute. It addresses many, many, many of our concerns about the filed version of the bill. Our primary reason for opposing SB 20 is that we believe the voters should decide whether prosecutors' policies are effective via elections. However, while we may disagree about whether the grounds for removing a prosecutor established in SB 20 are proper, we acknowledge that winning an election does not mean prosecutors are afforded unlimited power. Accordingly, I'd like to highlight 3 ways we think SB 20 could be improved to help ensure district and county attorneys are not inappropriately removed from office. First, the bill's definition of policy should provide prosecutors with more explicit guidance regarding what is considered an instruction or directive. These terms are too subjective and vague to provide prosecutors adequate notice regarding what could result in their removal. Second, it should be clear that prosecutors' use of pretrial diversion programs or specialty courts, which the legislature created based on evidence of their efficacy, does not constitute refusing to prosecute a case. And last, the bill refers to refusing to prosecute a class or type of criminal offense. That language is not currently included anywhere in Texas law. Limiting the phrase to a specific criminal offense would ensure prosecutors know exactly what SB 20 prohibits. Thank you for your time today, and happy to answer any questions.
Thank you for your testimony. Welcome, and please state your name for the record and give us your testimony.
Great. Thank you, Vice Chair Paxton and members, for allowing me to testify before you today. My name is Rebecca Parma, and I serve as the Legislative Director for Texas Right to Life. I'm testifying today in support of Senate Bill 20. We have strong protections for preborn Texans in our state. However, even before the Dobbs decision was handed down last year, the hidden underbelly of the pro-life movement is often a lack of full enforcement of the law. Leading up to and since the Dobbs decision, district attorneys across the country, including several in our great state, have made public statements declaring their intent not to fully enforce our pro-life laws. While district attorneys rightly have discretion over whether to prosecute case by case, they do not have the authority to adopt sweeping policies subverting the lawmaking authority of the legislature. These individuals are refusing to do their job, refusing to enforce laws duly passed by you all, our legislature, and putting lives at risk. They have proven themselves unreliable. We must have a way of holding them accountable. We support this bill as one method of holding such lawless district attorneys accountable. This bill would not only prohibit district attorneys from adopting or enforcing policies limiting enforcement of violation of laws, including our pro-life laws, but also from limiting others, such as police officers, from doing so. If they choose to violate this bill, prosecuting attorneys would be committing official misconduct and subject to removal from office. The legislature is in a unique moment in this first session post-Roe to pass substantial pro-life policies that continue to build a pro-life state. We must not let flagrant neglect of our laws become the status quo or undercut the gains we have made. We're thankful to the Lieutenant Governor for setting this bill as a priority and to Senator Huffman for carrying it, for the committee considering it. We look forward to your favorable consideration of SB 20. Thank you for your time, and I'm happy to answer any questions.
Thank you for your testimony. Welcome, and please state your name for the record and give us your testimony, sir.
Thank you, Madam Chair. My name is Dr. Joe Poyman. I'm the Executive Director of Texas Alliance for Life. We strongly support this bill, SB 20, and we thank Chair Huffman for authoring it. This bill successfully addresses a problem that we believe should be called a dereliction of duty by a small number of district attorneys in our state. We completely understand and appreciate the principle of prosecutorial discretion necessitated by limited resources or the goal of achieving justice in individual cases. Prosecutors will naturally prioritize prosecuting offenses on a case-by-case basis. However, a prosecutor should never categorically limit or prohibit the enforcement of a particular criminal offense unless ordered by court. Offenses are created by the legislature with the understanding that criminal laws are to be enforced, not ignored by police and prosecutors. However, we're seeing a substantial problem from a small number of district attorneys, who, by the way, happen to be from some of the largest counties in Texas. 5 district attorneys have published a very disturbing statement that they intend to completely and categorically ignore all felony laws passed by this legislature intended to protect unborn children and their mothers from abortion, even abortions on babies very late in pregnancy, up to birth. This is very disturbing to us, and we think it should be disturbing to everyone, regardless of how he or she feels about these particular pro-life laws. The shoe can be easily put on the other foot. We have heard and appreciate the argument that prosecutors are accountable to the voters in their districts and are up for re-election every 4 years. While this is certainly true, that statement gives us little comfort when the general statute of limitations for felony offenses is only 3 years. Thank you.
Thank you for your testimony. Members, are there any questions for the panel? Senator Middleton, you're recognized.
Thank you, Chair. Jennifer, I had a question for you here. So, you know, we've had a lot of discussions on this, and some things like, of course, what we've seen in Travis County, Dallas County has a policy of not prosecuting shoplifters, how this is compromising public safety. Can you maybe speak a little more on what this is doing for morale and cadet-sized classes for our police departments?
Sure. Yeah. I mean, this has a direct impact on morale. Like I said, you're booking individuals into jail because we're following state law, and we're called to the scene of these incidents. By the way, this is not proactive policing. No longer exists in the city of Austin. So these are calls that we are responding to, and so they're narcotics. Let's just use that for an example because those are felony offenses that are not being prosecuted here across the board. And so when you encounter these individuals, a lot of times there's a use of force involved or something of that nature that leads us down an entirely other path that is problematic in the city as well when it comes to morale. So you're taking once you've completed that, you're taking the individual, booking them into jail, and because of this standing order with our district judges, the individuals are actually being released from the jail prior to magistration, and sometimes it's literally within an hour. And so the officer hasn't even finished their report and gotten back out to take calls, and that drug user or drug dealer is back out on the street. So that's just an example of, for obvious reason, that is a morale killer, and it's a major problem in all of Travis County. It's not just the Austin Police Department, it's all the other agencies that book suspects into the Travis County Jail, which encompasses a lot of other smaller cities and the Travis County Sheriff's Office.
So our police officers are risking their lives for no outcome, essentially, because criminals aren't getting prosecuted. And, on our oath of office, we all take a same oath of office to protect, uphold, defend the laws of the state of Texas and Constitution of the state of Texas and laws and Constitution of the United States. That means all laws, right? That doesn't mean some. It doesn't mean that you get the cafeteria style, I'll pick and choose these, but not those. Do you think this is district attorneys violating that oath of office by choosing not to prosecute certain crimes?
Absolutely, because if I went to a call and I decided that for some reason I didn't believe in this particular offense personally, I don't get to make that decision. I take an oath and I uphold the laws of the state as a peace officer, so they should have to do the same. I don't see any difference, and they should be held accountable the exact way that a police officer would be if for some reason they decided that they didn't believe in a specific law on our books.
Thank you.
Thank you. Senator Perry, you're recognized.
Yeah, thank you. Same. Is it Jennifer?
Yes, sir.
It's good to have you here. I want to ask you a question you don't have an answer to, but it's really directed at multiple urbans. We have this conversation about Harris County, almost every committee. And Senator Huffman works on that diligently, as long as with Senator Whitmire and those from down there. But so ACLU made the comment, we think the voters should decide these issues. My question is, we are losing the PR campaign. I think regardless of political affiliation, somewhere along the lines, the side that we see not prosecuting law, not taking care of the criminal when they're captured and bail bonding and all. Somewhere along the way, the police, the citizenry have lost a voice in the PR campaign. We are a very shallow society. We get our news in 15-second sound bites. Typically, it comes from social media or alike. It's not based on fact, but as a citizenry, how do we engage the process to get the narrative turned? And y'all don't have time to promote the merits of policing and stuff, but I mean, these people that are making these decisions got elected. And so how do we get the message out that the people that you're electing are really undermining your safety and really not doing what you think common sense would assume is being done? And you may not have that answer, but somewhere in here, we've got to garner a PR campaign, for lack of a better term, that begins to turn the nut and the paradigm in all of these urban centers that have chose to not apply the law. And it creates a public instability. It takes public trust and credibility off the table when I've been down here for 73 days, whatever it is, every day Austin's on the news. And inevitably, what I hear through the news is this police officer was having to make a decision. Do I go to that murder, or do I stay on this murder, or do I go to this assault because of lack of enforcement? And so you can't answer this specifically, but if you have ideas or if you think that there's something that we can do as a citizen to get engaged, and I'm talking about somebody in Tahoka, Texas could have a voice for Austin, Texas to a campaign of some sort, but give some thought to that as an association and the public service side of that, the announcement side of that. But we have lost the narrative and we have lost our voice because there's no right-thinking citizen, not right in a political sense, that would suggest to you that what is going on in our urban centers is right, and it instills confidence that it's the right system to be under. So I don't know if you have a response to that. It's just we can pass laws all day long and we can punish those individuals that choose not to participate, but somewhere in the disconnect of these people that are voting in, that the voters don't know what's going on. So.
Well, I think, as an organization, we've been attempting that for several years now with this, a couple of our DAs. And the sad truth is that you have to come full circle. They don't listen to, the profession's not respected. We've been, shouting this for years. And until, there's enough victims of crime out there, because, unless it happens to you, right, it's not going to be out there or listened to, respected by elected officials. And so we're starting to see and come full circle now the results of the last 3 years. And that's the honest to God truth, is that until it gets really bad and then we completely, go the other way, no one listens at the front end. And that's what we've been trying to do. But we're one organization and it's difficult. So thank you again for this bill.
I'd say you have 181 members that run political campaigns that know how to get messaging out pretty well, because we only seem to garner 10% to get elected. I don't know if that's a good PR campaign or reflects where we're at in so many ways, but give some thought to it. You guys are a big group, and if there's things that we can do on a local level and get out there in front with voters and talk about some of the challenges. We get town halls. We have an agenda of 50,000 events to talk about when we get in those town halls. I think the people don't know what they don't know. And so I would recommend your groups, CLEAT, and the whole associations, if you will, to take a very active role in 31 Senate districts and take a very active role in your reps districts. And you may find nobody interested in some, the majority will, and we need to do a better job of really getting the narrative out that we're in a crisis mode. At some point you cross the Rubicon and it's too late. I don't know when that is, but we're at that tipping point in some areas of the state and this country for sure. And if we don't flip that switch back, then we look a lot like a banana republic. And I think that's a fair analogy of some areas of this country and even in this state at some level. So I would welcome conversations with your associations on how do we start a campaign on a very grassroots level to get the message out. And to your point, until it happens to you, it's not important. But our job, I think, from an elected position is to get the message out. And if you've got ideas on how to do that, I welcome them and would think that majority of the Senate, I know that, regardless of where you live, what I've seen is we very much understand what's going on and very much have a passion to try to turn the tide. So take advantage of us in some way if you can see a PR opportunity, or hook us to groups that can get a PR in there. Because when you get it out, when we do have a platform, when we do get that message out, people will pay attention, I think. It's just not personal enough right now. We need to make it personal. Thank you.
Thank you, Senator Perry. Members, are there any other questions for the witnesses? If not, thank you so much for coming today. Really appreciate you being here. Is there anyone else who wishes to testify on, for, or against Senate Bill 20? If not, the bill will be left pending. Thank you. Thank you, Senator Huffman. Senator Middleton, are you ready? Oh. It's not easy being a freshman, is it? You can stay in your seat. It's just the extended hazing period, right? Of course, of course. Thank you, Senator Huffman.
Yeah.
All right, the chair lays out Senate Bill 1575 and recognizes the author, Senator Middleton, to explain the bill.
Thank you, Chair, committee members. Today I'm laying out Senate Bill 1575. And this was brought to me by a member of the State Board of Education. And as this committee knows, we have 15 members of the State Board of Education that each have about 2 million constituents. And in their capacity as elected officials, they are often the tip of the spear of many laws related to education that we pass here in the legislature, including a number of proposed laws this session that would increase their authority over setting curriculum, standards, and oversight. And as part of that nature of their position, LJ Francis is here today, and there's a number of different entities that are eligible to request AG opinions. So what this bill would do is just add State Board of Education members as being able to request Attorney General opinions. And it's pretty much that simple. And all it would do is say the governor, the head of a Department of State government, the head of board of a penal institution, the head or board of an elementary institution, the head of a state board, a regional trustee of state educational institution, a committee of the House of the Legislature, county auditor, the chairman of a governing board of a river authority, and a member of the State Board of Education are eligible to request a Attorney General opinion. And we believe that this need will increase with the authority that our State Board of Education has in a number of different areas for our K-12 education system. So with that, I yield for questions.
Thank you, Senator Middleton. Members, are there any questions for Senator Middleton? If not, the chair calls LJ Francis as an invited witness. Welcome.
Good morning.
Thanks for being here. If you would just state your name and give us your testimony, please.
Good morning. My name is LJ Francis, State Board of Education member for District 2. Good morning, Senators. My name is LJ Francis, State Board of Education member for District 2, and I'm testifying before you in favor of SB 1575. As a newly elected State Board of Education member representing District 2 with Regional Education Service Centers 1, 2, and 3, I have been meeting with administrators, superintendents, and parents, and being an advocate for change and policies that enable parents to make decisions that are best for their children. As a State Board of Education member, we set policies and standards for Texas public schools with primary responsibilities to include setting curriculum standards, reviewing and adopting instructional materials, establishing graduation requirements, overseeing the Texas Permanent School Fund, appointing several members to military reservation special school districts, and reviewing the commissioner's proposed award of new charter schools. Recently, many constituents have raised concerns about their inability to seek legal guidance from their State Board of Education member on accountability standards and education issues at both the state and local levels, with many citing the issue as a restriction of their parental rights. SB 1575, as written, would seek to provide an additional source for concerned parties to request legal opinions on local and state education standards, policies, and regulations by amending Section 402.042B of the Texas Government Code that seeks to add a member of the State Board of Education as a requester for Attorney General's opinion. In closing, SB 1575 seeks to add a member of the State Board of Education to the list of officials approved to request an AG's opinion as an additional avenue for all interested parties to increase their involvement in their child's academic journey. This bill would provide an additional tool to ensure school accountability in delivering a high-quality education. Thank you, Senator Middleton and staff, and this committee for your consideration in voting this bill out of committee. Stand by for questions or reserve the right to close. Thanks.
Thank you so much for giving us your testimony this morning. Senator Middleton, do you have any questions for the witness?
Thank you for coming all day.
All right, thank you for being here.
No problem.
Chair opens public testimony and calls Jackie Bessinger. Jackie Bessinger. Thanks for coming this morning. If you'd state your name for the record and then give us your testimony, please.
Good day, community members. I am Jackie B. Singer. I hold an MBA and an MHA, and I am here representing myself and Moms for America and our over 1 million members. I am here today in favor of SB 1575. The reason why I'm here in favor for this bill is because our elected officials should have the opportunity to connect with their elected officials, same as we do as part of the community. I believe that this decision on improving the communication between the State Board of Education and the AG will improve and restore the K-12 public schools. Furthermore, I am asking for the support of a bill in a separate way that will help the State Board of Education have a separate power against the Texas Education Agency. I would like to see that the State Board of Education has a budget that oversees the statutory responsibilities stated in TEC Chapter 7, State Organization Subchapter D, State Board of Education 7.102. If they are elected, they should be able to communicate with any member at the Capitol.
Thank you so much for your testimony. Senator Middleton, any questions? All right. Thanks for coming today. Appreciate it. Is there anyone else wishing to testify on, for, or against Senate Bill 1575? Seeing none, the bill will be left pending. Thank you, Senator Middleton. And just to let everyone know kind of what we're expecting, we'll be going back into session at 11 o'clock. So we're going to recess until after that, and we will begin taking up the rest of the bills. But we need to give the Senate staff some time to get everything set up. So thank you all for being here today, and there's more after the session. So the Committee on State Affairs stands in recess until 30 minutes after recess or adjournment of the session. Thank you.